their conventional counterparts? Are they the same, these two things? That's a question that is still hanging. These agreements, because they were adopted before the GMO era, they don't really address this type of questions, or they don't have specific provisions referring to GMOs. And that question still remains. But Article XX of this agreement deal with exemptions. It basically says that in carrying out your trade practices, or to be more trade restrictive, you are allowed to do so, provided, for example, you are protecting human, animal, or plant life, or health. And then it has got a clause that refers to conservation of exhaustible national resources. And that's probably where the biodiversity GMO issues could be addressed in terms of exemptions when you go for more trade restrictive measures. But this must also not be done in an arbitrary manner, and it should also not discriminate unjustifiably. What it means is if you go more trade restrictive, make sure that it is not haphazardly applied, and that you can justify why you have to do that. And we will see what kind of information qualifies in this justification, which is obviously scientific information. So this agreement, or the agreements, does not accord a special status or does not have a direct reference to environmental exemptions. Neither is there a special status for the biosafety protocol. Nevertheless, as I have explained, biosafety issues could, by interpretation, be handled under those articles. The other article that could also be relevant for biosafety is the technical barriers on trade. And this agreement just furthers some of the objectives of the general agreement on trade and tariffs. It addresses specialized issues, this one and the SPS agreement that I will talk about in a minute. And the aim of the TBT agreement is to ensure that technical regulations and norms, including testing and certification, do not cause undue obstacles to trade. Already you could see that the labeling requirement of the protocol could be falling under the scope of this agreement. And what distinguishes whether a specific biosafety measure could fall under this one or the SPS agreement is merely the objective of the measure. If your objective is intended at technical information for the sake of, for example, informing, in case of, such as in case of the labeling requirements, then it will fall under this agreement. But if it is for the sake of protecting human and animal plant life, then it will be a measure that will be addressed under the SPS agreement. So it's really the objective of the measure that will determine under which agreement a measure will be handled. And of course, there are some articles that has got direct relevance for GMOs, and that's the articles I'm listing there, most relevant for the purpose of regulation. Non-discrimination of like products. Products that are the same should not be discriminated on in your regulation. And of course, the problem is, are GMOs substantially equivalent to their counterparts? Are they like products again? It's still a question mark. And this agreement does not clarify what like products could be. And again, this agreement has got an exception that for legitimate objectives, one could take more trade restrictive measures, and then it specifies one of the legitimate objectives could be protection of human health or safety, animal or plant life or health, or the environment. So there you could clearly see by interpretation, GMO regulations could also fall under these provisions. Now, the agreement that is most relevant for biosafety regulations is the sanitary and Phytosanitary Agreement, which deals with measures that may directly or indirectly affect international trade. And these are just extensions. This agreement operationalizes the agreement, GATT agreement on Article XXB, which deals with exemptions pertaining to exhaustible natural resources and the others that I have just mentioned. And it overlaps with biosafety because the rules are aimed at conserving biological diversity, taking into account human health. So to the fact that the biosafety protocol's objectives are exhaustible plant health and human health, it has got an overlap with the SPS objectives. Therefore, it falls under this agreement. Again, the countries can adopt higher standards, but only if there is scientific justification and it's not arbitrary, it's not scientifically unjustifiable, or is not discussed restriction on international trade. So there are all these caveats that really surrounds the issue of going for higher standards in your regulation that might affect international trade. Now, the fact that the precautionary principle is a principle under the SPS agreement, it could serve as a unifying principle between trade rules. However, this is also the basis of much divergence because the SPS formulation of the principle is only to the extent that you can scientifically justify the measures that you have taken, and it doesn't really have room for considering issues of scientific uncertainty or inconclusiveness, although it gives countries it allows countries to take measures like bans, but it should be within a reasonable time frame. And of course, the question of reasonable time also came up in the EC discussion of the case. Now, the case at hand. In 2000, several countries took the EC to the WTO dispute settlement body. They stated that the EC has got a de facto moratorium on the approval of certain GMOs in the EC because there were no approval or no decisions between 1998 and 2003 in the EC. So therefore, they interpreted that the EC has got a general ban on GMOs. The second complaint they had was that the various measures relating to specific products, they claimed that the EC did not approve 27 pending applications that was with the EC during this period. So they then interpreted that there is a WTO non-compliance regards the fact that the EC did not address the pending applications. And then before this, there were some GMOs that the EC had approved, but some member states refused, or they did not refuse, they actually were waiting for the labeling directive that was to be developed by the EC before they could consider allowing or not the specific GMOs that were approved by the EC. So it was really not a ban, but it was like, let me wait until I have got a framework in place that could allow me to deal with the GMOs at hand in terms of labeling requirements that we all know the EC public is very particular about. So that was the third complaint. And of course, the member states that did not, that applied this measure were the ones that is listed. Now, in its defense, the EC called for the use of the precautionary principle as an interpretive tool because they claim the principle is a general principle of international law And they also say that the CPT should apply in this case as it recognizes this principle and as the specific measure in question is really a CBD issue or the biosafety issue under the protocol. So they argued that in applying their agreements, the WTO should consider the broader context of international law instruments, specifically those that deals with the issue at hand. So the important question that could really give some kind of a relevance or importance for the biosafety protocol in the WTO jurisdiction or jurisprudence was whether the WTO panel could use non-WTO law in its dispute settlement body as applicable law, or whether they will consider the precautionary principle as a general or customary principle of international law, irrespective of whether it is really integrated in any instrument as a general principle of international law. Could the panel consider that? To answer this, the panel resorted to the Vienna Convention on the Law of Treaties, Article 31.3c, and ruled that it could take into account non-WTO instruments, but only those to which all disputing parties have consented. And we know the US has not consented to any of the instruments, for example, and some of the parties have consented to CBD but not to the protocol. So therefore, already this disqualifies the use of non-WTO instruments in this case. But many people argued that the fact that some of the disputing parties were members of the protocol could enable the panel to consider the protocol or in the CBD. But the panel again said the WTO instruments has more membership than the CBD and the protocol together. Oh, CBD and the protocol not together, but there is what they call treaty ranking in international law that they use to determine the relevance of a specific instrument. And I think the panel used that here to say that because the WTO has more coverage in terms of membership and the CBD and the protocol has got lesser numbers, therefore in terms of hierarchy, they cannot use these instruments. So based on this issue, the panel ruled using the SPS agreement that the measures that was instituted by the EC amounted to a ban, and that it was violating SPS measures because the specific directive that the EC was using to ban these measures addressed issues of human and animal plant health issues. Therefore, they concluded that it was an SPS measure. The EC again was arguing that these measures this dispute could be handled best by the TPT agreement because they claimed it was a legitimate objective to conserve plant life and animal health issues. But for some reason, the panel did not agree with that argument and rather resorted to the SPS agreement only to address the dispute. So they specifically focused on procedural aspects of the case and did not consider whether the risk issues that the EC was pointing out or was really relevant for ruling in the case. So they did not address issues of risk assessment. They did not look at substantive issues whether LM or GMOs are like products to non-GM to make their ruling. Rather, they said it is a procedural issue that needs to be handled on procedural basis only. And they ruled that according to Article 5.7, it was an undue delay that was not handled within reasonable time period. So the questions that stands out from this ruling is that what is the reasonable time period? Could the creation of scientific information be based on a specific technology? How much could be the reasonable time period to create or to look for that specific information? And therefore, this ruling or this formulation of the precautionary principle limits the adoption of science, where adoption of bans where science is uncertain or inconclusive. And this has got major implications for biosafety regulation, which is based on the precautionary principle. The panel was also silent on the relevance of the precautionary principle as a general law of international, as a general principle of international law or customary international law. So there is yet no case that could authoritatively inform whether this principle is having that status within the WTO, because this was the second case where the specific panels have refrained from pronouncing themselves on this principle. So it was only relied on in as much as it is enshrined in their agreement. General observations. This ruling of the panel reduced environmental concerns to mere animal and plant health issues. And as long as there is no other case in this regime that could really overrule this, this might have some authoritative influence on the future panels that might be dealing with issues of this nature. And many were surprised that the EC did not appeal, because according to the same article that the panel relied on, the protocol could not serve, yes, as an applicable source, but it could serve as an information source. It could inform the panel. Some authors also said, since the WTO doesn't have expertise in risk assessment, the protocol could serve as standards just to give guidance and information on these specific issues of risk assessment relating to biotech products. And also the CBD could add value to the poorly defined notions of the precautionary principle in the SPS agreement. And many commentators claim that this actually compromised the rule of law within the WTO itself, because it clearly disregarded some of the agreement, especially the TBT, that deals with the specific issues that the EC was raising. And